Monday, August 18th, 2025, and this is the City of Harrisburg Zoning Hearing Board meeting. We have three items on the agenda this evening. My name is Mike Pykosh. I'm the solicitor of the board. Here from my office with me is Michael O'Connor, and we have two board members present. We have Claude Phipps, who is the chair, and James Hobbs, who is the vice chair of the board. I just want to announce that we have a court reporter here, and we have a court reporter here because the zoning hearing board is more formal than the planning commission. It acts similar to a court of law. And when the zoning hearing board makes a decision, it makes a decision based upon the facts and the law, not what's popular or unpopular or what may deem to be a good project or a bad project. The applicant in each case has to meet a legal burden of proof that proves the elements of a variance or a special exception. And the law that the zoning hearing board will adhere to is the City of Harrisburg Zoning Code and the Pennsylvania Municipalities Planning Code. And with that being said, I just want to also mention that because there's a court reporter here, we want to make sure that we speak one at a time. We don't want to talk over one another. We want to make sure that the court reporter is able to take accurate word for word what is said during these proceedings. So the first matter before us is a matter of old business. It's application number 2610. This is a variance application for 508 and 510 North 2nd Street. It was an application that was filed by David Butcher with WCI Partners LP. And I understand, Mr. Schutte, you're here representing the applicant in that matter. Could you introduce yourself and whoever may be testifying on behalf of your client, and we'll swear them in.
Great. My name is David Schutte of Trout and Pepper Lock. I represent WCI Partners LP. With me is Dave Butcher, who's the president and partner at WCI, and Rich Gibble, who's the project architect, and he's with By Design.
Mr. Butcher, Mr. Gibble, could you please raise your right hands? Do you swear or affirm that the testimony you're about to give before this board is the truth and nothing but the truth?
Yes.
Okay. I also want to announce that from the city solicitor's office here, we have attorney Tersa Cameron. And then we also have Jeffrey Knight, who is the planning director for the city of Harrisburg. Mr. Knight, you will be giving testimony this evening. I'm going to swear you in, and by swearing you in, would you agree that you'll be sworn in for all the hearings this evening?
I do.
Mr. Knight, do you swear or affirm that the testimony you're about to give before this board is the truth and nothing but the truth?
I do.
Okay. Mr. Knight, could you give us just a general outline of this application?
Sure. So the project for case number 2610 involves the conversion of two buildings at 508 and 510 North 2nd Street into a total of 11 units. The applicants are proposing to develop 208 North 2nd Street into 5 units, and 508 North 2nd Street into 5 units, and 510 North 2nd Street into 6 units. The properties were formerly operating as a law office and became vacant. And as with other similar properties in the downtown where we have commercial uses and specifically office uses, whether those are lobbyists or law firms, there is a decreased demand for commercial in the downtown. So as with many of these other properties, the applicants are proposing a conversion and really a reversion back to the original residential use of these properties. In this case, they were probably originally single-family dwellings, but as noted, the applicants are proposing to have them be converted back into 5 and 6 unit buildings. In looking at the required zoning relief, the applicants do require a variance for relief from the density regulations in section 7-307.3 of the zoning code, which require 1,200 square feet of lot area per dwelling unit. So for the combined lot areas, the properties would be able to provide 3 units by right, and again, the applicants are requesting 11. In reviewing this application, we looked at basically 2 factors. One is the structural layout of the properties, and if you saw in the existing conditions photos included in the case report, the interior of the property is really not broken up into a normal floor arrangement where there's a consistent floor elevation across each of the buildings from the front to the back. They have a more staggered floor situation whereby the second floor of the back of the building is actually at about 2 or 3 feet lower than the second floor of the front of the building. And due to this configuration, as well as the thickness of the walls around the properties, in a lot of these older buildings, you have the original building constructed at the front, and then there's later additions on at the back. But because that original building was built to be lived in on its footprint, it had solid masonry walls or party walls if it's a shared space. And so between the elevation difference between the floors and the thickness of the walls, it makes the consolidation of these proposed units across the floors infeasible, at least without perhaps significant changes to the property, maybe bumping out a section here. Additionally, the internal staircase of each property and the common areas of the hallways pretty much can't be changed from where they're at now, just given the required widths and access to each of the floors. So it's not something where you could close off a portion of the hallway and create more space or create an easier connection between that. So for those physical reasons and those structural reasons of the building, there is a justification based on the configuration of the property. In addition, as the applicants noted pretty extensively in their supplemental narrative, there is a financial justification, which I know, as the board has heard before in the past, has been quoted as a justification for dimensional variances. So the applicants are also relying on the cost of purchasing, converting the building in their proposal, and I think they'll be able to speak a bit more to that in their testimony. So with all of that being said, the Planning Commission has recommended that the the zoning hearing board approve the request with the following conditions. If the applicant receives approval of the requisite zoning relief requests, they must secure city council approval of the associated land development plan for the proposed conversion, and that was submitted concurrently with the zoning relief request. So that, assuming approval at tonight's meeting, that application would move on to city council review. Any exterior alterations to the building will receive approval from the historic preservation specialist, or if necessary, receive harbor approval of a certificate of appropriateness application. And finally, the applicant will coordinate with the Department of Public Works to ensure that the account billing reflects the establishment of the proposed uses on site. And the Planning Commission recommended the zoning hearing board approve the request for the following reasons. The adaptive reuse of vacant and undesired office spaces compels significant investment that requires commensurate relief from the density regulations of the zoning code, as noted in the financial evaluation provided by the applicant in their supplemental narrative, and the unique interior configuration of split-level floors and thick masonry party walls precludes combining proposed units. Other conversions of former office buildings in the surrounding neighborhood have demonstrated the proposed use will not adversely impact the character of the neighborhood, and the project will help retain existing architecturally and historically significant buildings endangered not only by the threat of extended vacancy, but by the deteriorating buildings to the north. And finally, the proposed reuse will add new residents to the neighborhood to activate the street on nights and weekends and grow a customer base to support local businesses, and will provide additional housing units to the downtown inventory.
Okay, thank you, Mr. Knight. I want to mention that anyone who resides or owns property close to this project would be able to participate in this hearing. So I just want to ask, so we know, is there anybody here for this particular hearing? We'll let the record show that nobody indicated as such. Mr. Schutte, before you start, I want to mark some exhibits so we have them of record. These are all exhibits that the Zoning Hearing Board received as part of this application. I've marked them as board exhibits. So board exhibit number 1 is was the email of the applicant requesting a continuance to the August 18th, 2025 hearing. Board exhibit number 2 is the proof of publication. The time and place and particular nature of this matter appeared in the Patriot News on July 6th and July 13th, 2025. Patriot News being a newspaper of general circulation in the city of Harrisburg. Exhibit B3 is a letter dated August 12th, 2025, sent from the planning director, Jeffrey Knight, to the applicant, notifying the applicant of the time and place of the hearing. Board exhibit number 4, B4, is the hearing notice, which was posted upon the property, and that was accomplished on June 29th, 2025. Exhibit B5 is the applicant's notification letters to required neighbors. Exhibit B6 is the application package with attached narrative, letters of support, photos of the exterior of the property, and plans for the proposal. Board exhibit number 7 is the deed to the property establishing the applicant's standing to pursue the requested zoning relief. Board exhibit number 8 is the Planning Bureau case report, and board exhibit number 9 is the City of Harrisburg Planning Commission resolution. So we have exhibits B1 through B9. And with that, Mr. Schutte, you could proceed. Thanks.
I mentioned, my name is David Schutte. We represent WCI Partners LP. And with me is Dave Butcher and Rich Gibble. I've just provided each of you with an exhibit booklet. Just walk through these real quickly, the exhibits, and we'll refer back to them through the hearing. First exhibit is the deed to the property, evidencing standing to bring this matter. Exhibit 2 are the tax cards to the 2 properties. Exhibit 3 is a proposed floor plan for the property showing how the property will be developed and redeveloped. Exhibit 4 is a financial pro forma for developing the property. Exhibit 5 is a chart of past zoning hearing board variances granted for similar relief. And Exhibit 6 is a collection of letters of support that were received by Mr. Knight prior to the Planning Commission meeting. As mentioned by Mr. Knight, the subject property in this application is 508 and 510 North 2nd Street, which is owned by the applicant. The applicant acquired title of the property earlier this year. Subject property is currently approved with a vacant 3-floor office building, which was most recently used as the law offices for Wicks, Wagner, and Widener. According to the tax assessment records, the building, which has a demising wall to make it 2 properties on 2 lots, was originally built probably 100 to 125 years ago. Property is approximately 0.09 acres in total, and the building in total measures 7,341 square feet. Property is located in the CN zoning district, which permits by right the use of the property as a multifamily dwelling, and the applicant is proposing to develop the property with an 11-unit multifamily project. The applicant is also requesting a dimensional variance from Section 7-307A of the zoning ordinance, which limits lots in the CN district to 1,200 square feet per residential unit. Depending upon how this property is measured, whether it's one lot or two lots, the project under this ordinance is limited to only 2 or 3 units. As I mentioned before, the applicant is proposing 11 total units. I'm sure this board is very familiar with the necessary criteria to justify the grant of a variance, including that the applicant must demonstrate that suffering from an unnecessary hardship. Pennsylvania Supreme Court held in the Harrisburg versus Zoning Board of Adjustment case. And in the context of a dimensional variance, zoning hearing board may consider multiple factors in determining if an applicant has established an unnecessary hardship to justify dimensional variance. Those factors include the economic detriment to the applicant if the variance is denied, financial hardship created by any work necessary to bring the building into strict compliance with the zoning code, and the characteristics of the surrounding neighborhood. Zoning hearing boards and appellate courts often consider these factors in urban adaptive reuse cases similar to the instant application. The evidence we'll be presenting this evening will demonstrate that the subject property cannot be reasonably developed without the requested reduction in density to allow for the proposed 11 units. As Mr. Knight pointed out, the Planning Commission has recommended approval of this application with a handful of very reasonable conditions to which the applicant would agree to. With that background, I'll turn to Mr. Butcher as my first witness. Dave, can you provide your name, company, and position?
Yep. David Butcher, WCI Partners, position is president and partner.
And to the extent I said anything factual in my background presentation, do you adopt those as your own testimony?
Yes.
And what's the history of WCI?
Yeah, we were founded in 2005 to do redevelopment in the city. So we're a mission-based company. That's all we do. We develop and own real estate within the city boundaries. We've developed probably 400 units since then. Some office buildings too, in the downtown, midtown, some uptown area. And we've just been continuing to do that, develop and manage the properties here in the city.
And so you're quite experienced in development and redevelopment in
Yes.
the city. Okay, and you purchased this property about 2 months ago?
Yep, that's right.
And what was the intent of the purchase?
To do this project, convert it to 11 units.
Do you know how long the property was on the market before you purchased it?
I want to say 6 months. I don't know if that's precise, but that's the general. It was listed for a while, and then they lowered the price, and it sat for a while again. And then my understanding is they did not have very much interest.
And did you retain an architectural firm to prepare a proposed floor plan for the multifamily residential
We did,
use?
by design, represented by Rich Gribble.
And are the drawings in Exhibit 3, are those the ones that you're proposing for the project?
Yes.
Okay. And just, we'll ask Mr. Gribble to go deeper into this when he testifies. Can you just kind of go through those real quickly as to what you're envisioning here?
Yeah, so it's 11 units. There are 2 buildings, 2 separate lots. So each building would have 2 units per floor on the first floor, and then 2 units on each floor on the second floor. One building, the third floor doesn't go all the way back, so there'd be 1 unit on the third floor, and the other building would have 2 units because it goes the whole way back. So that's the 11 units total.
Okay. And do you intend to retain the historic facade and structure?
Yes, nothing will change on the exterior.
And plan on keeping the existing doors and existing interior staircases?
That's right. And I'd just amend my last statement. If anything does need to be changed per our investigation of the exterior, we would either seek HARB approval or be an in-kind replacement. But as of now, we don't intend to do any exterior changes.
Can you describe some of the challenges you generally face in redeveloping old office buildings into viable
Sure.
projects?
Yeah, there's a lot. A lot of these older buildings have a lot of unique physical conditions that don't make them easily adaptable. So it increases the costs of doing urban development versus, say, building on a new green lot somewhere in the suburbs. So there's a lot of unique challenges to these, and this building presents some of those. It's representative of those types of challenges that you run into.
As I mentioned earlier, depending on how the subject property lot is measured, whether it's one lot or two lots, the zoning ordinance limits you to 2 or 3 units. Can you explain to the board why you're requesting 11 units, which is in excess of the maximum permitted?
Yeah, two reasons. The main reason is that the unique physical circumstances in the building essentially determine the envelope of each apartment. So as Mr. Knight, I think, very well described, you have different elevation differences on the upper floors, so those units cannot be easily combined. You also have really thick party walls in between those two buildings. So again, it kind of prohibits the ability to easily combine those units without structural issues and then strange circulation patterns within those units. So what it creates is 11, use the word logical envelopes for apartments. It just lays out nicely for that.
And did you prepare a financial pro forma for this project?
I did.
Okay, and is the Exhibit 4 a correct copy of that?
That is, yes.
Hey, can you walk through in briefly how you calculated what the total cost of the project would be?
Yeah, sure. So total cost is determined by essentially 3 main buckets. You have your acquisition cost, you have your construction costs, and then you have soft costs. So you want me to itemize each of those?
No.
Okay.
But the way I read this, am I correct that your total cost for those 3 buckets is about 1.69 million?
That's right.
Okay. And then you also calculated what you think the value of the property would be after construction. Can you go through how you calculated that?
Sure. All commercial real estate, whether it's office or residential, is valued essentially on what's called an income capitalization approach. So you take the income and you subtract out the operating expenses of the property, and you come up with what's called the NOI, or net operating income. And then buildings, appraisers typically apply what's called a cap rate. It's essentially a dividend rate, as if you paid all cash for the property. What would be the return on that? And that's the cap rate or dividend. So a building of this size, this vintage, this number of units, the 7% cap rate is very much in line with what an appraiser would use for this. So we're simply taking the net operating income, you divide it by the cap rate, and that's how you arrive at the value of 1.68 million.
Okay, so then the cost, in fact, is greater than your calculated value?
That's correct.
Okay, and if, say you did 8 or 9 units instead of 11 units, how would that affect the pro forma?
Negatively, because the savings in cost per unit would be lower than the saving, or than the value lost. So there's a disproportionate from the savings to the loss in value. A simpler way to think about it is that reducing each unit's bathroom and kitchen might save you $50,000, but you're losing about $150,000 per unit in value, roughly.
So you came up with 11 units. first, because it fits the building very
Right.
well.
That's
And
right.
secondly, because that is the number that that you almost break even at.
Just about, hopefully.
Okay. And so I'm correct that the variance being requested is not to maximize profits, not to get as many units as you possibly can in the building to maximize your profit and rents, but instead just so that so that the project pencils.
Yeah, we're trying to make the project pencil, and that's typical of the types of projects we've been doing over the last 20 years. We call ourselves a patient capital company, and we do projects that are generally low or virtually immediate, no return, but we hold them over the long term. Yes, that's, in short, yes.
Yes. Okay, and to be certain, is there any vacant property contiguous to this property that you could acquire in order to get closer to the amount?
Well, there are vacant buildings contiguous to this, but they are slotted for demolition, and that is not something that we would want to take on to this project.
Correct. Okay. And then, have you, on behalf of WCI, or other developers you're aware have been granted a similar variance by this board in the past?
Yes.
Okay. Let's take a quick look at Exhibit 5. It shows a handful of, or more of, past variances that have been granted to Harristown, to Doug Neidig, and to you. And taking a look at the approved density, which is, I think, column third from the right, is that the resulting square footage per unit?
That is the resulting square footage of the so unit divided by the lot. And one thing I just want to point out with this spreadsheet, this also includes projects and zones that don't require the density relief. So in the DC and in the INS, but it was just, those are included just to show some comparisons, but you don't have the relief or the unit relief factor. But if you look at the projects just in the CN zone, so our project is at the very bottom proposed. Our unit relief factor of 5 and 6, which is just simply derived by taking the total number of units that we're requesting and dividing it by what's actually permitted, you see that we're very much in line with other projects that have been approved in the CN zone up above. And then the approved density, so the lower the number, the higher the density that's been granted. So we are requesting a density for 508 of 467 per unit, and then 510, 320 square feet per unit. I just want to emphasize that is not square footage of the units. It's square footage of the density per the lot square footage. It's a little.
Yeah, but that's actually the precise reduction from the 1,200.
Correct.
Requirement, or precise what that 1,200 becomes as a result of the variance that's been granted.
That's right.
Okay. And is this project in line with at least some of these other projects that you mentioned that are in the CN district in size and scope?
In line and also less relief if calculated by the approved density of some of those other projects. Yes.
And also, I just want to mention to the board that this is, although not on this chart, last month, I believe in July, this board granted similar relief to 315 North 2nd Street, a similar type of application, but it's not on this chart. And are you aware of any support letters you've received with respect to this application?
Yes, we met with the Downtown Improvement District, Historic Harrisburg Association. We toured the project with them, and then I spoke with the Capital Area Neighbors at their monthly meeting. We received a unanimous vote of the Capital Area Neighbors.
And it does Exhibit 6 have copies of the letters that were sent to Mr. Knight
Yes.
with respect to that support.
Yes.
Okay, so to recap, what are the physical circumstances and conditions of subject property that are causing the hardship?
Yeah, as described by Mr. Knight and then earlier, it is the differences in the floor elevation on the second and third floor, the thick party walls in between the areas where the envelopes of the units. Yeah, and those are just the physical.
Yep. And how do those conditions affect the development of the subject property?
They effectively restrain and determine the number of units and the layout of the units.
And and also as to the hardship, would you even be able to do the project economically if you did not have 11 units?
No, we couldn't proceed.
Okay. Considering that the building was originally constructed over 100 years ago and WCI purchased it 2 months ago, safe to say that the hardship was not created by the applicant.
Correct.
And can you describe the surrounding neighborhood?
Yeah, the capital area neighborhood is really lovely. It's a nice mix of residential and commercial. It's been shifting lately, particularly around the State Street area where we are, to more residential as small commercial office buildings have sat vacant. There's been an effort to renovate those properties into residential.
If this variance is granted, will the project alter the essential character of the neighborhood or district in which the project is located?
Will it alter?
Yeah.
Positively, we believe, yes.
Okay, if the variance is granted, will the project substantially or permanently impair the appropriate use or development of the adjacent property?
No.
If the variance is granted, will the project be detrimental to the public welfare?
No.
And does this variance represent the minimum variance that will afford relief and allow you to move forward with the project?
Yes.
I have no further questions for Mr. Butcher.
Okay, we'll ask the board if they have any questions, but before we do, Mr. Schutte, you had mentioned at 315 North Second Street. I think that appears on your list. It's on the last one in under approved other projects.
Well, Dave added it.
I may have added.
I just want to make
Okay.
sure for the
Okay.
record.
Okay, yep, that's, yeah, it is. You added it.
Okay. Does anybody from the board, Mr. Phipps or Mr. Hobbs, do you have any questions of Mr. Butcher?
Good evening, gentlemen. I was looking, a lot of notes here. So, thank you for the financial document in the back. It basically, I see that this is an investment of 25 years, so you're going to be here for a while.
Yeah.
Okay. And you're the owner, your WCI will be the owner of the building.
Yep.
Okay. I also saw that the apartments that you're basically going to be recommending for the 11, they're all one-bedroom apartments.
Yep.
And the average floor space size is about 450 square feet. 468, I think is the book here.
Yeah, about 4.
That's used, and you consider that usable space.
Yeah, that's probably right. Yeah, and it's very similar to one of our most popular properties is Union Lofts. It's at 922 North 3rd Street. Those are about 470 to 90 square feet. Very similar, efficiently designed, but very popular.
The price point is between $1,000 to $1,100.
That's right.
I hate the term when they use multifamily dwellings. Yes, it's multifamily is not going to fit in one of those apartments. It's going to be basically obstruct people who are starting out.
Right.
You said the physical layout of the second floor it slopes by about 3 feet down.
Mm-hmm.
Okay, so I'm just trying to form my question the proper way. We look at square feet. We're looking at floor space, but we're not looking at the depth. When we basically do those calculations, we look at the depth of the spaces of each of the apartments. I When I say space,
Do you mean the like volume, like
Volume,
the height of the, yeah, I mean, that's not generally a consideration and,
okay. I did see something, I saw the recap from the planning bureau. There were some questions raised about the financial hardship. And I think their concern was is that this could be a slippery slope if we start looking at everything with financial hardship issues. And Ms. Cameron, you were there and you were looking at it too. You say by basically, when you do this project, in 25 years, you still won't break even. That's what, when I look at your financials, and that's what you said. You won't get back total cost of the buying property and rehabbing the property. You still won't break even.
That's right, on a straight cash on cash basis, correct.
So I'm gonna ask you, more moral question. Why would you enter something when you're not gonna break even?
Mm. Well, there's ways to manage that. One is to bring in financing, and then you can amortize out your principal loan over time, so that'll help. I think I'm trying to think of a succinct way to describe this. So our company was formed from the sale of an internet company in 2005. One of our main partners, Alex, owned that company. The partners took proceeds from that sale and formed our company. And the goal was, Harrisburg has been very good to us. Let's form a company to go do urban redevelopment in the city. Our goal is not to make money here. We made our money in this internet business. So we're taking a piece of that and creating this company. And that's been our goal. We're mission-based. We don't do development elsewhere but in the city of Harrisburg. And every project we've done has been similar to this. It's often low return, sometimes no return on a cash basis. We hold them a long time, and we amortize out that. We collect rents enough. Every year I build a budget, and I hope to break even to be able to pay staff, pay maintenance, all the other expenses. That's our goal every year, to keep going and keep doing this.
Thank you. More altruistic instead of profit driven.
We call it patient capital or social capital, I guess, is part of they consider that as part of the portfolio, yes.
Forgive me, I went past your places. I have this tendency of always going past looking at anything I don't want to, that comes to help me, so I understand a little bit about it. I know how to phone a question, just to say delay. Okay, but, more to the questions. Again, you're asking for a financial hardship because of the density issues.
Yes.
That's all the questions I have. Thank you.
Good evening. Just a few questions. So you mentioned, well, I guess, so WCI, right, in all of your experience in developing in the city, you've been through the zoning process before, correct? So I'm just curious, was there a reason why you, I guess, didn't finalize zoning request before closing on the sale of the property?
I think we felt an urgency to close on the building, to take possession of it, and then figure out what we could do with it. We had a motivated seller, and they were moving out of the city, and they didn't want to wait a long time for us to get entitlements. So we took that risk based upon our experience and getting approvals for similar type projects in the past. We felt that this was in line with those types of projects in the past.
Got you. Is there thought on what would be your option in the case of, thought about if the case, or if the application wasn't approved for zoning, what would be your use of the property?
I think that would be a challenge to figure out. I think leaving it as office would not work. And by work, I mean it just, there's just not right now, I think there's about 1 million square feet of vacant office space downtown. That was a calculation I heard recently. there's a glut of office space. It's really hard to lease this. So um, without approval, probably the best move for us would be to sell it to another owner who may be able to figure something out that we can't figure out and move on.
Okay, thank you. So, question somewhat on the lines of Mr. Claude had about the hardship and what you just mentioned about commercial space. And I definitely like to get clarity on that topic as well. It's just always an interesting one with the applications we get. And there have been some, like you pointed out, I think recently that have passed, but also ones that have been denied where it was more of a commercial use as opposed to residential use. And so we do often get the comments about the cost of the redevelopment of existing buildings, especially some of these older buildings. But what is can you give additional insight on that barometer, right, in terms of, apart from generally saying that it's hard to lease out office space in downtown Harrisburg, like what specifics have you evaluated? You know, if you do have any things in terms of specific figures, or even, you know, something that may be a little bit general, but what exactly is being evaluated to make that determination that office space is not going to be a viable option for this particular parcel, or two parcels?
So we own some office space in the city, and it sits a long time. And just doing this for 20 years now, having a lot of conversations with commercial brokers, owning some office space, it's very difficult to get rents. It's very difficult to find a tenant that wants, the term for these types of buildings is Class B, Class C typically. It's just not in demand. And so it's very difficult to find a tenant. And if you do find a tenant, the rent rates are so low, you're barely covering your expenses. So let alone, you know, overhead, staff, management, maintenance, things like that. So you're better off, we would be better off, even though we are a patient capital company that doesn't seek a return, a high return, it would not make sense to hold on to it.
Got you. Okay. I think my last question was just about, I did see the letters of support that were garnered for this particular application. They seem to all, I think, 3B from organizations, but I was just wondering, was there any dialogue with residents in the area as opposed to just representatives of businesses?
Yeah, and I should clarify, so Capital Area Neighbors is a organization of residents in that area. So when I went to the meeting, they had their monthly meeting, and I want to say there was about 30 to 35 neighborhood residents there, and I spoke to all of them. They asked me questions about the project, and I just, you know, explained everything for about an hour, and then they took a vote. I don't know the exact number of residents on their board, but it's probably 12-ish. And they all took a vote, and I received notice from Mr. Santana, who signed the letter on behalf of the 30 residents, that it was a unanimous vote of the members of the Capital Area Neighborhood. So I think that is the best way for us to reach the neighborhood residents, was through that organization.
Got you. Appreciate the clarification.
Sure.
That's all that.
Mr. Nutt, I just had a quick question. Mr. Butcher just talked about the amount of vacant square footage of office space in the city as being about 1 million square feet. Does the city have any records on that? Would you think that that's about right, or?
I think it's difficult for me to say. Maybe our tax enforcement office would have some more information on that, because they'd know who's not like re-upping and renewing leases. I do know, I don't have specifics on that, but I do know that, for example, I think the state is consolidating. The state's obviously a major purchaser, leaser of space downtown, and they're consolidating their footprint. So, you know, I know if they're kind of contracting with regards to the amount of office space they have, it's similar for other organizations downtown. So it's definitely an overall trend. I can't say what the specific number is, though.
But is it your observation that there is more vacant commercial space in the city than is being used?
Oh, absolutely.
Okay. Okay. Yes. Yeah.
I look at your spreadsheet again, and I'm looking at both properties, you basically got them for $365,000. And I look at your construction cost is $1.1 million to basically, and that's to address building of the 11 apartments.
Mm-hmm.
The question I'm trying to raise is that, so if let's say you have to conform to the density requirements, that means it's 1, 2, 3, 4, because you can count all 3 floors, right? So basically, it would be 3 apartments per unit, which would total up to 6 instead of, I'm just trying to think, Jeff, I'm helping out this. It was first floor, second floor, third floor apartments. Okay.
I think they would only be able to have 3 total.
3 total?
Yeah, total.
3
For
total
both-
per building?
No, for both buildings.
Yes, it would be 3 total based on the square footage of the lot on which the buildings sit. So, the buildings obviously themselves have a larger square footage than what the lot is. I think when I did the calculations, it was like 3.5. So between 3 and 4.
So I'm not looking at the buildings, I'm looking at the lot itself. And the lot's been subdivided, so now you don't get a benefit for that. That would basically say $100,000 a living space. That's what that basically comes back to being, okay? And you would basically look at basically, if you don't get this tonight, putting it back on the market as houses. I mean, it's a living space.
Yeah, we just put it back on the market and, yeah, see what.
Okay, thank you.
Ms. Cameron, do you have any questions of Mr. Butcher? Okay. Mr. Shitty, do you want to call your next witness?
Sure, next witness is, Rich Gribble. Mr. Gribble, for whom do you work?
By Design Consultants, Architects.
And are you a professional architect?
Yes, I am.
And are you licensed in the Commonwealth of Pennsylvania?
Yes, I am.
And have you worked on projects in the past in the city of Harrisburg?
Yes, I have.
Have you worked on redevelopment projects similar to this one?
Yes.
Okay, and did you oversee the designs that are included in the exhibit booklet?
Yes, I did.
Okay. Just generally, amplify some of the things that Mr. Butcher testified to. Could you explain some of the challenges in redeveloping a property like this?
So the challenge is that the building was built 100 years ago. Like, that's the first challenge. And these buildings were, back then people lived differently, right? And this particular building has multiple levels, as you've heard tonight, multiple steps throughout the space, which does make it tricky to develop because obviously different floor levels, different ceiling levels, and how you access each of those spaces.
And is the 11-unit design shown on Exhibit 3, is that the most practical and useful way to develop the property?
Because of the way the building's, again, laid out, as we've heard tonight, with the front and the back being at different levels, that is the most practical way to lay it out.
And would cost not an issue if you were to, cost or ordinance not an issue, if you were to see this in front of you and think, okay, what's the most sensible way to use this space? Would it be how you have it set up on this
Based on various other projects that we've done in the city, apartments that we know are, that rent well in the city, apartments that lay out well, absolutely agree with that.
I have no further questions.
Does the board have any questions for Mr. Gribble?
probably one question, and should have asked this. Fire evacuation, in the front of the building, any in the back, any fire escapes or something? Have you
Yes.
something like that? Okay.
Yeah, so the building will be fully sprinklered, but there is the front exit, the front stairway, but the back of the units have either back doors that exit out, or they exit onto balconies with stairs or fire escapes off them.
All right, thank you. Yeah, I only have one question.
Mr. Mr. Hobbs, you have any questions, Mr. Ribble? Ms. Cameron, do you have any questions of this witness? Okay. Seeing no more questions,
Just have a quick summation. First, I'm going to move for the admission of applicants' exhibits 1 through 6.
they're admitted into evidence. Yep.
Okay, and as I mentioned at the beginning, it's a dimensional variance, which has a relaxed standard for determining whether an unnecessary hardship exists, and as such, the zoning hearing board may consider additional factors, including the economics of the project and the possible economic detriment to the applicant, and the cost to meet the requirements of the code. And the pro forma that we presented to you, applicant clearly shows that the project only works if there are 11 units, and then just barely. The request is not an attempt to maximize profits, but instead just to make the project pencil so that it can be done. And so that this property can be used again for a viable use. Certainly, as was testified to, the physical characteristics of the property also size of the lot, historical nature, and the different elevations within the building are part of the cause to this hardship. And the hardship was not created by the applicant, and the project is harmonious with the neighborhood without detriment to the public welfare. And finally, the requested variance is the least modification necessary to move forward with the project. So we are requesting that the variance be granted, subject to the conditions set forth in the Planning Bureau case report and the Planning Commission's resolution.
Okay, thank you, Mr. Schutte. Okay, we're going to take a few minutes break and discuss some legal issues with the board, and then we'll be right back pretty shortly. So we'll go off the record now.
You know, that's how I am, man. I'm always like, y'all just pick on me. Well,
you for your patience. We'll go back on the record. Is there a member of the board that would like to make a motion in this matter?
I'd like to make a motion that we approve the variance request with the conditions set by the Planning Commission.
Okay, moved. Is there a second?
Second.
Moved and second. All those in favor signify by saying aye.
Aye.
Okay. Unanimously passes. We'll issue a written decision within 45 days of today's hearing. And that's it. Thank you for your time.
Usually don't get hoots and hollers.
Okay, next we're going to move into the first item on new business, application number 2611. This is a variance and special exception application for 1932 Forester Street. It's a property located in a residential medium density zone, filed by Yennefer Martinez? Yennefer Martinez. And the application is to convert an existing single-family dwelling to a two-unit multifamily dwelling. Ms. Martinez, are you here on your own? Do you have any other witnesses?
Just myself.
Okay. Could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give before this board is the truth and nothing but the truth?
I do.
Okay. And Mr. Knight, you were sworn in a previous hearing, and you agree that you continue to be sworn in. Is that correct?
I do.
I'm going to mark exhibits for this matter. I'm going to mark exhibits that the board previously received. They're all board exhibits. The first one is Exhibit B1. It's the proof of publication. The time and place and particular nature of this matter was published in Patriot News, which is a newspaper of general circulation for the city of Harrisburg. It appeared on July 6th and July 13th, 2025. Exhibit B2 is a letter dated August 12th, 2025, sent from the planning director, Jeffrey Knight, to the applicant, notifying the applicant of the time and place of the hearing. Board Exhibit number 3, B3, is the hearing notice posted upon the property, and that was accomplished on July 30th, 2025. Exhibit B4 is the application package with the attached narrative, photos of the interior of the property, plans for proposal, and documentation in support of the application. Board Exhibit number 5 is the deed to the property establishing the applicant's standing to pursue the requested zoning relief. Board Exhibit number 6 is the Planning Bureau case report, and Board Exhibit number 7 is the City of Harrisburg Planning Commission resolution. So they're exhibits B1 through B7. Mr. Knight, would you like to give a summary of the application, please?
Sure. So the issues inherent in case number 2611 for 1932 Forster Street are fairly typical of similar conversion proposals that this board sees and the city sees on a fairly regular basis. In this case, the property is one half of a duplex. And being in the residential medium density zoning district, and given the size of the building and the size of the lot, the proposal requires 2 special exceptions: one for the use in the multifamily dwelling use in the RM zoning district, and another for relief from off-street parking. Although per testimony at the Planning Commission meeting, the applicant is able to provide 2 off-street parking spaces at the rear of the property, accessible from York Street. And then two variances as well, one for relief from the density regulations in section 7-307.3A of the zoning code, which require 1,500 square feet of lot area per dwelling unit, and then one for relief from the specific criteria in section 7-309.2V of the zoning code, which requires a structure be 2,500 square feet in order to be, a single-family dwelling be 2,500 square feet in order to be converted to multiple units. With respect to the variances, the property itself is a 2,200 square foot lot, so it would be 700 square feet short of by right allowance of 2 units. As noted in the testimony at the Planning Commission meeting, the applicant does own the adjacent vacant lot to the west at 1930 Forster Street, and if they were to consolidate those lots through a lot consolidation process, which is an administrative process, they would be in conformance with that aspect of the zoning code. So they do have that existing lot condition that they own a vacant lot directly adjacent to the subject property. And with respect to the relief from the specific criteria, the Planning Bureau notes that the county's records list the property as 2,202 square feet, but the applicant has noted in their application that it is actually 2,499 square feet, so that would be 1 foot short of being a by right allowance for conversion of the property, and therefore be a de minimis variance. We're not quite sure where that discrepancy is from, although it may relate to a 2017 building permit for work on the property, which we believe is the enclosure of the front porch, which added the additional space onto the building square footage, and a porch itself would not constitute square footage for the purposes of the building measurement or sales of a building. However, an enclosed front room, such as the existing property features, would be towards that. So the relief is either for 298 square feet or 1 square foot, based on those two considerations. As noted, it would be a de minimis variance if it were the latter of those two. The applicant notes that they purchased the property last year, I believe in April of 2024, and purchased it directly from the previous owner. They did not use a realtor, but were sold the property as is in the 2-unit configuration by that individual. The Codes Bureau's records and the Planning Bureau's records show the property to be a single unit, so it was likely that this was converted without the appropriate permits and without the appropriate work at some point in the past. And again, this is a fairly common situation here in the city, although in many cases, I would say the circumstances of the property are different. If you're the center unit in a row, for example, or in a more denser neighborhood, you would not have the same sort of conditions that the subject property does, where you have a larger lot, you have direct access to the rear of the property. The lot is wide enough to provide two off-street parking spaces on site. Even though there is this was illegally converted without permits, we are not necessarily trying to authorize or formalize that as a regular course of doing business here in the Planning Bureau. We do feel that this particular property does have conditions inherent in it that do support not only the special exception requests, but the zoning requests as well. So with that being said, the Planning Commission recommended the Zoning Hearing Board approve the request with the following conditions. If granted zoning approval to move forward with the project as proposed, the applicant shall allow the Codes Bureau to perform a comprehensive inspection to identify any outstanding code violations, and will receive approval for all necessary city permits prior to receiving a certificate of occupancy. As the applicant testified to at the Planning Commission meeting, the Codes Bureau did inspect the upper unit, but they did not want to move forward with inspection of the first floor unit until the applicant they could confirm the applicant got approval of the requisite zoning relief. So this would require them to go back in and check that floor out. And then the applicant must provide a detailed site plan developed by a professional demonstrating how the rear yard will be developed and whether off-street parking will be provided on site. If that is the intention, any new development must be in conformance with the applicable zoning regulations. And per some of the informal documentation we have seen in coordination with the applicant, they are installing two concrete channels for the off-street parking. So we don't think there's a concern about exceeding the maximum impervious lot coverage. There won't be any concerns about stormwater runoff. They are permitted to have the parking in the rear yard setback, accessible from York Street. So as a general rule, we do think that they are able to provide this. We would like to see still a detailed site plan, assuming they get approval from the zoning hearing board. The Planning Commission recommends the zoning hearing board approve the request for the following reasons. While the Planning Bureau does not believe that the existence of illegally established units on site creates a basis for the establishment of a hardship or justification for zoning relief requests, as that may only encourage such work, in this instance, the subject property does exhibit conditions that support the granting of zoning relief, including the size of the structure, the possibility to construct off-street parking on site, and the applicant's ownership of the adjacent vacant lot, which, if consolidated with the subject property, would obviate the need for a variance for relief from the density regulations. The property can address the primary concern of the public regarding such conversions, specifically the impact on parking available to existing residents through the provision of the required parking in a new parking area at the rear of the property, and due to the availability of ample on-street parking along the frontage of the property with Forster Street. And finally, the existence of other such conversions in the surrounding neighborhood demonstrates the allowance of a new such conversion would not adversely impact the community.
Thank you, Mr. Knight. I also want to mention that the city solicitor's office is represented this evening by Attorney Tersa Cameron. And I just want to also ask if there's anybody here present this evening that resides or owns property next to this project that would like to participate in this matter. If there is, please let me know now. Okay. Okay. State your name, please. You come up to the microphone.
My name is Manuel Maldonado.
Okay. And are you a neighbor?
I actually lived at that property, and I'm a neighbor to the other one.
Okay. Do you want to make a comment at the end, or?
The property, it's...
Well, not right now, but do you want to, at some time during the hearing, do you want to make a comment?
Yes.
Either for or against? Okay. Why don't you take a seat right here, right behind the applicant, so you're there. And when we get to that point, I just wanted to identify, and then we'll identify you for the record. Okay? And then, Mr. Knight, was the applicant to provide notification to of the neighbors of this application?
Yes, applicants are required to provide the notification letter to all all property owners within 100 feet of the subject property and proof of first-class mailing.
Okay. Was that completed? Do you have that here?
No, I'm sorry, I didn't know I was supposed to bring it, but Mr. Knight did provide me with the list of everyone that I needed to go to, and I did mail it out to them. I didn't bring, I don't know what I was supposed to bring regarding that.
Okay.
But I did mail it out to everyone that was on the list.
Okay. So that's a requirement that it's part of what the ordinance provides. At this point in time, if you want to proceed, you could proceed at your risk. At some point in time, if somebody should appeal this, you're going to have to provide that information, if there might be an appeal.
Absolutely.
Okay. Do you want to proceed with your case then?
Yes.
Go ahead. You could go ahead.
So as Mr. Knight said, I purchased the property over a year ago. I didn't buy it with a realtor. I purchased it from the previous owner himself. He lived on the apartment downstairs, the first floor, and he was renting the upstairs. I actually saw that he had rental inspections done before, which were for the upstairs unit. I checked with the Dauphin County website. It's provided as one of my exhibits. Dauphin County website still has it up until then, because the issue was brought up. It's listed as a multifamily, so I did check that before purchasing it. But after that, once it was brought up, when I pulled the permits, it was an issue with Mr. Bruce upstairs at our codes, where he was the one that stated, hey, this is a one-family, and I was pulling permits for it as a two-family. Once the issue was brought up and I provided him with the information from Dauphin County, it was, I guess, reached out to them. It's been corrected as of 2025, but from before, the county website, if you go to the tax year, the record, it shows as a multifamily going back to as far back as you're able to check. So I never knew that it wasn't a legal two-family until I went to pull the permits. At which point, then once I found out, I contacted Mr. Knight. I went to his office and started the process for this zoning board. The property has everything already separate. It has 2 separate electrical panels, 2 separate meters, 2 separate water heaters. It even has hardwire fire alarms, and it's 2 different sets of fire alarms. So in case there was a fire, they would have never went off together because the first floor is wired together and the second floor is wired separate from the first floor. The first floor is a whole unit on its own, and so is the second floor and third floor. It has its separate kitchen, as you can see from the exhibits, the kitchen, separate bathrooms, 2 entrances, separate entrances. One is to the front of the house. So if you're going to the first floor apartment, to apartment 1, you enter through the front of the building. The second floor, you enter it from the side where there's a very wide sidewalk to enter from the side. Then they have 2 separate entrances also on the rear of the property. So they each have an entrance and exit, downstairs and upstairs. They function as 2 complete separate units and have been that way for many years. As I stated before, the owner lived in one unit and rented the other one. I have already created the 2 parking spaces in the rear of the property. And it also has its signs that says tenant parking. And it's the 2 separate parking spaces with separate signs and all of that, so that they're easily differentiated, that is for the 2 units. The adjacent lot, as Mr. Knight said, I own that one as well. Part of the sidewalk on the side of 1932 Forster, this property that I'm here for now, the sidewalk, 4 feet of it goes actually into the adjacent lot, which makes it very wide. It's like I think it's 6 or 7 feet wide in order to get to the back of the property and to the side of it. Not that it's needed, because this one has its own, but it also has, I guess, the sidewalk from the previous, from the adjacent lot as well. These codes officers went there June 6th, Officer Yurovich and Williams. They both went there. They inspected both units. Both units, they were in compliance. However, they stated that because as per codes, it's only a one family, that they cannot put that both apartments passed inspection. They can only say, you know, you know what I mean? Like, they can't say apartment one, these were their exact words. We can't say apartment one passed inspection and apartment two passed inspection because legally, it's just one house. But they're both up to code. They told me, and I told them that I was going through this process. So they said, once this is done, call us, let us back in, and then we can put it in the system that apartment one and apartment two both passed inspection. Until then, they can't. I also called them after that because I thought it was a condition that needed to be met before the zoning board. Once I went to the planning commission and this was brought up, I thought I needed to meet the conditions before this hearing today. So I did call the officer again. I said, and I asked them if they can come and do the inspection before today because it was a condition. And they were advised by Mr. Knight that they cannot, that it would need to be after this, that I need to meet the conditions.
Okay,
That's it.
okay. Did you, Ms. Martinez, did you take a look at the Planning Bureau case report? And the Planning Bureau, they recommended approval and they had 2 conditions. Are you agreeable to those 2 conditions?
Absolutely, yes.
Okay. Does the board have any questions of Ms. Martinez?
I have a question, not necessarily to Ms. Martinez, but so there was a discrepancy mentioned right in terms of the square footage of the lot. Which value should we be using as the official number for this application?
No, it was, I think discrepancy was in the building, not the lot, just for clarification.
Oh, got you. Well, yes, but I guess either way, then what should we be using?
I mean, I would say without, I don't know, I guess either an architect's measurement of the building or another county assessor going out. It's tough to say exactly which is the correct number. It would be my best guess that it would be closer to the 2,499 square footage because of that enclosed front porch than the 2,200 referenced in the county's records.
Gotcha. And then just my other question is, so even though the city's records had it as a single unit, I'm just wondering, like, the fact that there is actually 2 separate electric meters, is that what you stated,
Yes.
correct? Wouldn't there have had to been some type of approval through the city for them to install another meter for a second meter at that property?
So that actually, to my knowledge, that doesn't happen. If like somebody calls out PP&L to come out and put a second meter on, PP&L will not check with the city, and I think this is because they're. I believe this is the case that as a public utility, they're not beholden to the city's regulations. They're managed by the state Public Utility Commission, so like they don't have to coordinate with the city when they do stuff like that.
Okay.
Can I answer that? So when an electrician goes to pull a permit with the city, if they pull the permit, it's actually the electrician that calls their supervisor, which is the one with the master, with the master license. That person then sends a cut-in card to PP&L, and PP&L just brings it out. That it's left to between the city and the electrician and the master electrician to figure out all of that. Once the cut-in card is sent in, then PP&L just brings it out. And as far as the square footage discrepancy of the building, as Mr. Knight said, what happened is back in 2017, per code's record, a permit was pulled for them to enclose an area of the house. So there was an addition done. Once it was completed in 2018, the property was brought into compliance with the new addition having been added. So the addition, it was legally done, permits were pulled, it was inspected by codes, but it's just that the county records were just not updated. But
Gotcha.
what's there was inspected with, as far as insulation, electrical, everything.
Got you. Okay, thank you.
Welcome.
Good evening. I had a couple of questions, and I've talked with Director of Mr. Knight about this a little bit. When you bought this property, you went out, you saw it before you acquired it. So you saw the fact that there was 2 meters and everything else in, okay? When you closed on this, you closed on it. Your deed, what did your deed say? Did your deed say a single-family dwelling?
The deed, I believe it doesn't state that it's a single family. I believe it just says the property.
It'll say
Right,
any structures on the, the type of structure on the building on a deed, should be. Okay, so,
But even if it did say one family, by the time that I get to see the deed, it's already been recorded with the county and then it gets sent to me by mail. So I don't really, it would have been too late anyways for me to say, no, I'm not purchasing it. I was already, I didn't have doubts. Like if you see the
that's what
property, you wouldn't doubt that. I didn't question it.
okay, well,
So even if the deed say one family, I wouldn't have noticed it and it wouldn't have stood out to me like, hey, it's one, because everything of it was, a two-family, nothing.
that's going to go back to my next question. So when you went out and bought this property, and did you intend it to be a single-family dwelling or multiple? Or what was your intent in buying it? Multi-family dwelling or single?
Again, it never even crossed my mind, the one family, two family, because it was a two-family. It looks like a two-family. The county says it's a two-family. It was just never a
So you made that
question.
assumption, your assumption you acquired this because it was a multi-family dwelling, and that became,
I went to the property, I saw it multiple times before purchasing it. There isn't even a way to get from the first floor to the second floor from inside.
okay.
Some two families in the city of Harrisburg, there's a front door and then there's a stairs to go up to the second floor unit, which is like the property where Manuel lives. It's 1927 bricks. It's a two-family. You go in through the front door, the stairs will take you to there's two doors. One door takes you to the second floor unit, and then the other door takes you to the first floor. So that, I could see it if it was like that, but it's not even like that. One door, the front door takes you to the first floor, then you have to kind of go around to the side and go. So I never even said, am I gonna use this as a two-family? It's way too big to be a two-family, and it has two kitchens, two living rooms and everything, so it never even crossed my mind, am I gonna use this as a one-family? It would be very difficult to convert it to one, to make a way to get from one to the other, and eliminate a kitchen and everything.
Well, that leads me into one of my final questions. So you looked at this, okay, two families, so you made that assumption. What did your insurance, okay, you've got insurance on this property. What did your,
They had
insurance
it-
people tell you? What was their designation?
So they have it as a two-family as well. When it was insured before that, it was insured as a two-family. There was actually a fire at that property a few years before, and when they did the insurance claim, it was a two-family. The insurance, it's in my narrative. They also have it, insurance companies, they share information.
Okay.
So when I called my insurance company, which isn't, I'm pretty sure it's not whoever they had before, I don't know who they had before, but there's a national record. And they said that they had it as a two-family, and they paid it as a two-family with the fire. And the neighbors also told me that it was always a two-family. Like I said, Manuel told me he's lived on Brick Street nearby for many years, and he knew the man that lived on this property, which is Forster, and he knows that the man lived downstairs, and it was always rented upstairs. At some point, his nephew lived upstairs, and then it was rented, and the city has the rental inspections for them. But they did a part of it because he lived on the other part.
Okay. I'm just looking here. I'm looking at one of the exhibits that you submitted, your business privilege tax, okay? But the issue I see is that you show the address on Briggs Street, and this is Foster Street.
That's just my landlord license.
Okay,
It's just, yeah, that's just my landlord license.
okay.
That
So
I,
then your landlord, so
so
again,
that
that goes
property,
back to my intent question. So you've got a landlord license, it almost implies that this is, you're recognizing this as a two-family dwelling. Okay, a multi-family dwelling.
I'm a landlord in the city of Harrisburg. I own a lot of property, so
okay.
that's my license
Okay,
showing that I'm a landlord, that property is registered as a rental property under my landlord license. That's why I provided that, my landlord license. I paid the fees to have it as a rental property.
okay. That's all the questions I have, thanks.
You're welcome.
And Mr. Phipps, with regards to the deed, that was part of Exhibit B5. The deed, the only mention I see on here with regard to your question is it says having thereon erected a 2.5-story brick dwelling being known and numbered as 1932 Forester Street. It doesn't designate, yeah.
Okay. Most of my questions are geared towards their conversions of property in the city from single-family dwellings to multifamily dwellings, and the records necessary to record that. So it's represented properly by the city and the county, because they both got to be in sync. Okay, so.
I found out with this property that Mr. Knight and Bruce were like, never go off of the county record. We've been trying for years to get them in sync, and it just they're not.
Okay. Thank you.
Ms. Cameron, do you have any questions?
No, I don't. And I would just like to say to Chairman Phipps that, right, her landlord license would show her address or any company that she would be using to represent her as a landlord. So that wouldn't be indicative of what is taking place at the residence.
Is there anything else? Sir, could you come to the mic and just tell us your name and spell your last name so the court reporter could have it?
My first name is Manuel, Manuel. Last name Maldonado, Maldonado.
Okay. And do you live close by to this unit?
Yes, I do.
Okay. How close?
Next door.
Okay. Go ahead. You want to tell us? What would you like to?
The property's always been known as a two-family unit. And my friend used to actually live upstairs from the previous owner that had it. And that was 4 years ago.
Okay. And I think Ms. Martinez had indicated that, do you have any knowledge that there were two separate units and two separate individuals living in those units?
Yes.
Okay. Okay. Is there anything else?
No.
Okay. Thank you.
You're welcome.
Okay. We'll do the same as the last case. We'll go off the record and we'll return shortly.
Silence all your communication devices. It's going to help us
Okay, we're going to go back on the record. Is there a member of the board that would like to make a motion in this matter?
Yes, I'd like to make a motion to vote to approve the application 2611 with the conditions set forth by the Planning Commission.
Moved by Mr. Hobbs. Is there a second?
I recuse myself. I second. Okay.
Moved and seconded. All those in favor signify by saying aye.
Aye.
Okay, motion carries. Ms. Martinez, you'll receive a written decision of the decision made this evening within 45 days of this hearing.
Thank you so much.
Thank you.
What's that?
We started at 6:00.
I came close.
Yeah. Is this the next one?
In the back of the decision where they actually approved the special.
Were we here? Oh, really? Okay, the last item on the agenda this evening is application number 2612. This is a special exception application for 2609 North Front Street. This is a property which is in the Riverfront zoning district. It was filed by Noah Parsons of Triple P Fitness, and it's to replace existing front yard grass with AstroTurf. So, Mr. Parsons?
Yep.
Yeah, that's you. And who's with you this evening?
My name's Chris Braun. I'm the synthetic turf representative.
What's your last name again?
Braun, B-R-A-U-N.
B-R-A-U-N.
I'm the one that worked with them for the proposal to put this, not AstroTurf, synthetic turf.
Okay. Mr. Parsons and Mr. Braun, could you please raise your right hand? Do you swear or affirm that the testimony you're about to give before this board will be the truth and nothing but the truth?
Yes.
Okay. Mr. Knight, you're already sworn in. I'm just going to go over the exhibits in this matter, and then we'll go to Mr. Knight. I have pre-marked exhibits that the zoning hearing board had previously received in this matter. They are Exhibit B1, which is the proof of publication. The time and place and particular nature of this matter was advertised in the Patriot News, which is a newspaper of general circulation for the city of Harrisburg. It had appeared in publication on July 6th and July 13th, 2025. Exhibit B2 is a letter dated August 12, 2025, sent from the planning director, Jeffrey Knight, to the applicant, notifying the applicant of the time and place of this hearing. Board Exhibit number 3 is the hearing notice posted upon the property in question, which was accomplished on July 30th, 2025. Exhibit B4 is the notification letters to the required neighbors and certificate of mailing. Board Exhibit number 5 is the application packet with attached narrative, photos of the existing condition of the property, plans for the proposal, and petition of community support for the proposal. Board Exhibit number 6 is the deed to the property. Board Exhibit number 7 is the Planning Bureau case report. And Board Exhibit number 8 is the City of Harrisburg Planning Commission resolution. Mr. Knight, do you want to give a synopsis? Oh, just for the record, again, because each one of these is a separate record, we have Tirsa Cameron from the City Solicitor's Office here. And then, Mr. Knight, if you want to give us a summary of the application, please.
Sure. So with respect to case number 2612 for 2609 North Front Street, is a special exception request, effectively for development within the front yard setback of a property along Front Street. Bit of a unique situation and a unique request. We don't get kind of a lot of these along Front Street, and just due to the nature of the request, where there's not really a new structure or thing like a parking pad, it doesn't maybe spring to mind as kind of a sensible, like, why are we here kind of thing. But because the front yard will be dug up and the underlying substrate below the proposed synthetic turf will have to be engineered. It'll have to be compacted soil and gravel for infiltration of stormwater. It does constitute development, which is prohibited in the 50-foot yard, 50-foot front yard setback of riverfront zone properties north of Riley Street. In this case, because normally this would require a variance application for encroachment into a setback, but because there is already an existing accessory parking lot at the north side of the front lawn, there is already encroachment into a majority of the front yard setback, except for about 2 or 3 feet along the sidewalk. And as such, this represents an expansion of an existing non-conforming aspect of the site. And because of that, it requires a special exception and not a variance application. For that reason, the Planning Bureau eventually recommended support. It was our initial kind of approach to the project that we were concerned about the precedent it would set of having synthetic turf be replacing front yard grass, not just because Riverfront Park is a probably one of our higher profile and more conspicuous corridors here in the city, but somebody else could say, like, maybe I just don't want to mow my lawn anymore, and it would be preferable to have synthetic turf here, and that would certainly, I would say, have an adverse impact on the character of the Front Street corridor. Additionally, while we certainly appreciate the utility of this proposal to the applicant, they will not be the owner of this property or user of this property, in perpetuity. And so whomever comes after this, it may have less utility for them, or they may use it in a different way. So for that, we were a bit kind of hesitant in our approach to the development, but in the fact that it was a special exception and not a variance, and because of that, the standard of proof and the burden of proof on the applicant is lower, we eventually felt that the proposal did merit a recommendation of approval from the Bureau, with, of course, the conditions outlined in the Planning Bureau's case report, and which were adopted by the Planning Commission, which include the following. The proposed turf may be installed no further into the setback than the existing parking surface, and the applicant must reinstall the landscape screening along the parking area, which was recently removed in violation of the parking facility design standards, and install landscape screening along the frontage with the sidewalk. And so if you've been by the property, you'll note that there's the tan bark between the parking area and the sidewalk, and we'd like to see that the landscape screening replaced there and also extended along the frontage of the property with the sidewalk there. The applicant should relocate the pedestrian connection to the public sidewalk to the southern frontage of the parking area to retain a direct pedestrian connection to the building and ensure that pedestrians are not required to intermingle with vehicular traffic to access the building. In the testimony at the Planning Commission meeting, the applicant noted that the proposed ADA ramp which will run along the building instead of the existing pathway that runs out to the sidewalk, will basically run into the parking area, and it was agreed, at least with the Planning Bureau, that the applicant could just stripe the existing concrete, like they wouldn't have to pave a new concrete walkway. They could just stripe the existing asphalt, as a pedestrian connection, but we did feel it was important to retain that connection so that there was a direct way for pedestrians to walk up to the property and go to the front door. Again, in consideration of the future users and the future businesses that might be there, and the fact that they are along Riverfront Park where the greenbelt is, and he may have clients coming via that way instead of driving to the property. The applicant must remove the unpermitted pennant signs along the frontage of the property. Given the location within the AE floodplain, The applicant must ensure that any investments to the property are submitted to the Planning Bureau for consideration and review against the floodplain regulations and best practices before work can commence. The turf and ramp, as well as an unrelated fence project submitted separately from the zoning relief request, must be included in that floodplain development submission. And then the applicant will coordinate with and receive approvals from Capital Region Water regarding all drainage and stormwater management issues. And then finally, no parking will be permitted on the front yard area impacted by the project. The Planning Commission recommends that the Zoning Hearing Board approve the request for the following reasons. Although the Planning Bureau is skeptical the proposed turf will replicate the appearance or functionality of natural grass and is concerned about the proposal establishing a precedent for other Front Street property owners, the project must only receive approval of a special exception application, the threshold for which is lower than for a variance. The project could function as something of a test case to determine how well the proposed project integrates both aesthetically and functionally into the Front Street corridor. And then finally, if the conditions of approval are adopted by the zoning code or by the zoning hearing board, the project could result in an overall benefit to the viability and utility of the property while addressing various zoning violations on site.
Okay. At this point, as we did in the other hearings, and there's a number of people here, is there anybody here that resides or owns property close to this application, this project, that would want to speak in this matter? Okay. Mr. Parsons, do you want to proceed with your case?
Sir.
Go ahead.
Yep, so we are seeking zoning relief to replace our front yard grass area with a permeable turf system. As Chris mentioned, it's not astroturf or sports turf. It's natural looking, designed to look specifically like grass. It's called soft lawn barefoot comfort. So it's designed to look exactly like grass. This turf will be used solely for supervised personal training, private personal training. There will be no public access, no speakers, and all equipment that is brought out during the day for training will be brought in by the end of the day. The project improves stormwater conditions as we're removing 2 concrete walkways and adding a small ADA ramp, like Mr. Knight mentioned, resulting in a net reduction of 175 square feet of impervious surface. The turf drains at over 600 inches per hour. It was recently tested, which is far beyond traditional grass or concrete. As you can see, we've gathered hundreds of signatures and support, both from local residents and our clients and community. We're committed to keeping the space safe, clean, and visually appealing, and we believe this investment improves our property, aligns with the city's goals for wellness and small business growth, and sets a new positive example for Front Street. That's all I have.
Okay. Is there any questions of Mr. Parsons? Mr. Parsons?
Hello, Mr. Parsons. I only have a couple of questions, and you've answered one with the drainage. Have you basically talked to Capital Region Water about stormwater runoff and how this would be, and have you submitted a plan to them to let them know what you're going to do?
We have not submitted a plan to them, as that was just a condition in terms of the planning commission that we had just decided on the other week. However, I know Chris has just tested it recently and can provide details there.
Okay. So you haven't, as I say, one of the requirements is that this has to be reviewed by Capital Region.
Yeah.
I think the director, Claire Mulhern, she handles a lot of this.
Okay.
Okay.
Is that for us to contact, or?
You should. Again, it was stated that you would basically require them to review the replacement of the grass with this, what your temporary replace, or temp grass, I'll just do it that way.
And presuming zoning hearing board approval, I would put them in contact with representatives from Capital Region Water tomorrow.
Okay. that's the only question I really had was how you handle stormwater runoff and talking with Capital Reach and I. Okay.
Good evening, Mr. Parsons. Just one question. So like, can you describe, like, what is your main, I guess, need for the turf, or like, what is the benefit that you're trying to garner through the installation of this material?
Yeah, so primarily an extended training space for our clients and our business. However, also we recognize that, as Mr. Knight mentioned, it's a unique situation. So for us to create something different that can make an impact both on our business and the city of Harrisburg in a positive manner.
Okay. I just think my other question then is, and I'm assuming it's minimal, but are there any, I guess, special considerations or anything specific required for maintenance of that type of material once it's installed?
Sure.
I guess it's for Mr. Brown, I guess.
I mean, they're super low maintenance, okay? Could we come by and brush it every once in a while? Yes, okay? He just needs to keep it clean and keep the debris off of it. And that's basically all you really need to do. And it's a lifetime warranty. Prorated, but lifetime.
Got you. All right, thank you.
No access to the public. This is basically for your facility.
That's correct.
So there's no public right-of-way or anything else. Your kids basically decide they want to play football.
Mr. Parson, what type of training will be performed on this turf?
So primarily strength training, cardiovascular. So I think when you look at turf outside, you can do a lot of agility, sprints, stretching, calisthenics, things of that nature.
Okay. Are you going to have any equipment out on this surface?
Yeah, so any equipment we bring in would be just weight benches and weights from inside the gym, and then that would be all brought back into the gym by the
Okay. Was the city aware of that?
Yeah,
Okay.
they've been clear throughout the process that they intend on, basically bringing the inside out as part of this. And they'll be taking everything in at the end of the day, so it's not like weight benches or, I don't know, sleds or something like that. That'll be out there overnight.
Like a temporary Venice Beach, right? And I just want to, I think, know for the record that you were here and you were granted relief originally back in 2023 for your facility. Do you recall that? Right. Okay. And then, Mr. Braun, say in the future, some subsequent owner, or even sometime in the future, Mr. Parson should decide, hey, I'm going to remove this turf, for lack of a better word. What's entailed to do that if somebody wants to replant grass?
I mean, part of the process, especially, with the water, is we're gonna put a drainage system underneath. Basically, it's a few inches of 2B modified, and then tighter stone to make it smoother. That would just have to be removed,
Okay. And could you bring one of those pieces up here so the board could see, yeah.
They were intrigued last time.
What that one?
Same thing, they both look at.
I was just curious as to. We have our little piece down here.
We'll play football in that.
Yeah. Ms. Cameron, do you have any questions of either of the two witnesses? Is there anything more that you'd like to present? Okay. Okay.
Well, just want to note, I don't know if you want to ask for comments from the public. There's a lot of them here. So.
Yeah,
Okay.
I
Oh,
think we
sorry. Okay.
talked that nobody, yeah, we asked that and they
Okay,
indicated
gotcha.
they didn't want to. Okay. They're like supporters, I believe, of the applicant. Okay, we're going to take a short break again, so we'll go off the record and we'll be back shortly. Okay, we're going to go back on the record. This is, again, for application number 2612, special exception application for 2609 North Front Street. Is there a motion?
Yes, I would like to make a motion for the special exception application 2612 with the conditions set forth by the Planning Commission.
So is that, Mr. Hobbs, is that a motion to approve?
Yes, a motion to approve.
Okay, with the conditions set forth by the Planning Commission. Is there a second? Moved and seconded. All those in favor signify by saying aye.
Aye.
Okay, congratulations. You'll get a written You'll get a written decision within 45 days of today's hearing. Thank you. Yep. Here's your grass.
Hello. So I'll make a motion that the meeting will be adjourned.
Second.
I'll send you guys an email tomorrow and include the contacts.
Thanks.
No problem. I'll tell you. Sometimes I'm sitting there like shooting my nails about it. Like I look down and they're like all raggedy. I get like it's like bleeding in the corners.
We're going to go, Jeff, we're going to go on the record one more time, with just one extra piece of business for the record. Previously, because of an issue with one of the board members not being able to be here, we designated the other, in this case, Mr. Phipps, to be the hearing officer in one of the cases. And I just wanted to put on record, if from now until the end of the year, I wanted to see if there would be a motion that if any one of the two of you should not be able to appear for a hearing, that the other who does appear will be designated as the hearing officer for the board to hear any application before the board that particular month. Would somebody make that motion?
Okay, I make a motion that going forward from now to the end of the year, that in a case of where both of our board members are not available, the board member that is available would be appointed the hearing officer to allow the, allow the zoning session to continue, okay?
Okay. Yeah. So as I indicated, if one of you is missing, the other one will be the hearing officer in that situation. So there's a motion from Mr. Phipps. Is there a second?
So moved.
Moved in second. All those in favor signify by saying aye.
Aye.
Okay, thanks. I just wanted to cover that just in case. Okay, thank you.
Night, everyone.
I don't know what it is, but it's gonna be short.
When's the next,
Next Tuesday.
what we want to do is, Mr. Hobbs and myself, to basically go in front of city council and make a request, okay? Because again, you can put in a difficult position. This last case is a perfect example. It was not construction, it wasn't development, that should never have come.
Well, you want to make a request for what?
Some help, if the city council will appoint, somebody from the city, and a few representatives to sit down, and talk about zoning rules. It's currently, what we currently have in the books right now, because again, this, with the house conversions, we're gonna get this, we're gonna get a lot of those. And this last one was a little touchy, okay, and when I say touchy, I couldn't recuse myself because it had been denied, because I did not wanna go for that, okay? You're not gonna benefit from illegal action, I don't think that's right. That's why I'm trying to.
When you say the last one.